very much for coming and for attending this very, very important press conference which has been called by Swaram. For over a week, there have been some media reports on the issue of the submarine purchase from France by the Malaysian government have actually received a lot of controversial reactions, a lot of controversial news reporting, including the fact that it was brought up in Parliament and including the fact that there were many questions that remain unanswered or that remain in grey areas on the issue of the purchase and on the issue of public money spent. On my immediate right is Mr. Joseph Braham. I hope I'm saying it right.
No problem.
He is a lawyer that Swaram has sought assistance, among the lawyers that Swaram has sought assistance to help us pursue a case and a complaint at the French courts. And this is among the issues that we will be discussing today.
We are a law firm specialized in human rights and anti-corruption issues. To give you a few examples, we are for the moment suing 3 African head of states for misappropriation of public assets in France. We are suing international companies, I mean, of course not on our behalf, but on behalf of clients. We are suing French multinational companies for corruption case, for bribery, for misappropriation, once again, of public assets. So I guess that's why Swaram came and see us in this case. So I will briefly explain why and on which ground we had French jurisdiction in this case. And then I'll finish with at which stage of the French legal system we are right now, and then on the next step that could be that we could reach. So first of all, you have to understand that the only thing the French jurisdiction will dwell into is corruption, is commission paid by DCN or by, we do not know exactly whom yet, but by allegedly DCN and armories. So this means that the murder of Altantuya Shaharibu has nothing to do with the French jurisdiction. It is not allowed for a French judge to investigate on Altantuya's case, first. And why is it done that the French court have jurisdiction over the corruption? It is very easily because during a parliament session, the government, I think it was the minister of the former minister of defense and now prime minister, explained that the government never paid any commission to Perimeco, never paid the 114 million euros commission to Perimeco, but that DCN did pay. And therefore, since DCN paid, and DCN is a French citizen, then the French judge are competent, have jurisdiction over this alleged corruption. First element. That is the reason why we have a French jurisdiction. And now, so based on this, we filed a complaint, 10 pages complaint here, that we sent to the French judges. And these judges considered that there were enough elements, and I will explain which elements later on. And the judges considered that there were enough elements to open an inquiry. This means that now they have seized the best French financial police section to delve into what has happened, where is the money coming from, where is the money going, is it staying in Malaysia, or is there some kickback commissions? As you might be aware of, DCN is quite well known in France for let's say, pay commission and that sometimes get back in France. There is the Pakistanis and the Taiwanese cases. And so the ground used, the ground that the French judicial system considered strong enough to open an inquiry as are quite simple. There are, in fact, three main elements. First, Perimeter, who is the company who received 114 million euros. Perimeter was created only in 2001. This is 1 year before, a few months before the contract was definitely signed. The submarine contract was definitely signed. This means that Perimeter has no experience at all in submarine deals, has no experience in logistics, has no experience in nothing regarding submarines, first. Second, Perimeter, till this contract, had never had any contract with any company. The only thing Perimeter had done till the signature of this 114 million euros contract was losing 75,000 ringgit in 2002. That was the only thing that Perimeter had ever done. And third reason for the third ground for opening the inquiry is that the wife of one of the main counselor of the yet Prime Minister of Malaysia is one of the directors of Perimeter, and this was considered by the French judges as something, by the French prosecution, was considered as something very important. These are the three main elements. But in this case, I think what is really important is to understand that the French independent judicial power considered that there was sufficient evidence of alleged corruption by DCN on Malaysian government. And in fact, of course, even though DCN paid, we all know that in fact the bill, the 1,014 million euros were added to the bill of the submarines. Therefore, Malaysian taxpayers are the one who paid in fact.
The issue of Perimeter being registered in 2001, I think is a very, very important point. After the sales were actually made. And Perimeter is actually wholly owned by another company called KS Ombak Laut Sendirian Berhad. KS Ombak Laut Sendirian Berhad, which is the company which was controlled by Abdul Razak Baginda's wife, whose name is Mazlinda, and she was the principal shareholder of this company, of Ombak Laut, who also owned Perimeter. So there are a lot of questions with regard to the payment of 114 million euros, why? And also I think the other issue that was raised in Parliament, which probably already caught your attention, was the issue of maintenance of the submarines, because when you actually purchase such defense equipment, you need to have a budget for maintenance. And I think the issue of the cost with regard to the payment for maintenance was also another cause for concern, because it was a payment which was supposed to amount to 270 million ringgit for a total number of 6 years.